It's my honor and great pleasure to introduce Professor Elizabeth Brake, who is our keynote speaker this afternoon. All three of us, when we were thinking who to invite as the keynote, had Professor Brake at the top of our lists, and we were so thrilled and delighted when she accepted our invitation. She is a professor of philosophy at Rice University. She is the author of over 30 published articles spanning topics like love, marriage, personhood, parenthood, rights and social connection, procreative ethics, disaster ethics, polyamory, and a lot more. She's also edited two collected volumes, and perhaps most influentially, she's the author of Minimizing Marriage, which was published by Oxford University Press in 2012, which means this is its 10th anniversary, which makes me feel kind of old, but also I think we should applaud this. This is a milestone. This book has been massively influential on my own work and many others besides me. It was an honorable mention for the APA Book Prize in 2014. It's been translated into Japanese. And that chapter 4, where Professor Brake coins the term Amato-normativity and explains what that is, has been absolutely revolutionary for the field of philosophy of love and philosophy of relationships. Recently, Professor Brake has been collaborating on a very exciting project with my colleague at UBC, Professor Kimberly Brownlee, which is looking at social rights and relationship goods. And this includes a really exciting online talk series, which I would highly recommend everyone go Google and check out. My co-organizer, Justin Clardy, has given one of these online talks, which I believe is a companion piece to the Amato-normativity arguments, looking specifically at Black polyamorous situations. So yeah, highly recommend those talks. Many other great people in there too. But okay, that's enough of me withering on. I'm sure you all don't want to hear what I've got to say, but what Professor Brake has to say, so please join me in welcoming her.
Thank you so much, Carrie. So can everybody hear me? Can you hear me at the back? Okay, great. Well, thank you so much to the organizers, Carrie and Ellie and Justin. I know this has been a lot of work, but I'm so honored and delighted to be here. And I've also learned so much in the past couple of days from all of the talks. I've been wanting to change my slides because there have been so many great new ideas about non-monogamy in the talks so far. So it's just an amazing body of new work, I think, that they've brought together. It's a really wonderful experience to be part of. So I didn't assume that everybody at the conference would be familiar with my work. I see there are some people here who are not from the conference who might not have read my book. So this talk will be familiar. About the first half of it will be really familiar to a lot of you, because I'm going to talk about some of those ideas from Minimizing Marriage. And then in the second part, I'll start to raise some new problems and kind of grapple with them a little bit. Sorry, I'm getting the hang of this laptop. So my work starts, the kind of starting point of my thoughts about marriage and family and kinship law is the question, what role should the state be playing in marriage and in personal relationships more generally? So the state can play a lot of different roles in relationships. It can incentivize or penalize entry into them or exit from them. It can prohibit or criminalize them. It can protect and support them. It can collect data on them. Right? So the state plays many different roles in relationships. So the kind of foundational normative question is, what role should the state play in marriage and personal relationships in general? And so I'll be talking about that in the first half of the talk. And then I'll switch to a problem for non-monogamies and legal recognition of non-monogamies and polyamory specifically, which is actually a problem that I know Francesca Miccoli talked a little bit about earlier. I think it's a problem that really is kind of important in thinking about whether it's even worth pursuing legal recognition for polyamory as a political cause. And that's the question, would state recognition suddenly coerce polyamorous to assimilate to dominant norms of relationship. So it's a question that's really, I'm just borrowing from kind of queer theoretical debates over marriage, like, is it even worth seeking same-sex marriage as a political goal? I mean, sure, it might be it might be a requirement of equal treatment to have same-sex marriage, but is this really the best political goal? Is it even a self-defeating political goal? So I'll spend some time at the end talking about that question. Okay, so an overview of the talk. So I'll start out by talking about marriage equality arguments. I'm going to go way back to the 1990s and start out by talking about kind of marriage equality arguments for same-sex marriage, and then talk about Amato-normative discrimination and monoto-normative discrimination and what those entail for the shape that marriage law should take in an ideally just society. And then confront what I think is the really big question for someone with my starting point. Why should the state be involved in marriage at all? Why not just abolish marriage as something that's inherently unjust, that has a really bad track record? Why should the state be involved in our intimate lives at all? And then finally, I'm going to switch to that question. Well, how can the law recognize non-monogamies without subtly pressuring non-monogamists to enter into kind of dominant norms of relationships? Okay, so the starting point, as I said, is equality arguments for same-sex marriage. I'd like to start here. I agree with these arguments as far as they go. I just don't think they go far enough. Right, so the reasoning of equality arguments for same-sex marriage, which were coming out in philosophy in the 1990s and early 2000s by people like Rafe Wedgwood and Adrian Wellington, the idea of these arguments was marriage law performs a certain function. It recognizes adult relationships that have certain features, right? And Wedgwood and Wellington characterize these essential features differently. So for example, Wedgwood focuses on economic and domestic cooperation, sexual intimacy, and voluntary commitment. Wellington, as you can see, characterizes them slightly differently. But the point is, look, if these are the kind of relationships that marriage law recognizes, protects, and supports, well, same-sex relationships are relevantly similar. They perform the same kind of functions. And so it seems that equal treatment requires recognizing same-sex relationships as well, because they perform the same type of functions which the relationships recognized under current marriage law perform. Another part of this argument that both Wedgwood and Wellington rely on is the idea of neutrality, right? So liberal neutrality is a very controversial doctrine. Neutrality prohibits discrimination on ethical or religious grounds. So ethical or religious grounds from within comprehensive doctrines, doctrines about the good life, about all of the ethical meaning throughout all of life, those can't be the basis for law and policy. So neutrality rules those out. So the essential argument here, the essential liberal argument for same-sex marriage combines equal treatment with neutrality and says, look, unless there's some good reason not to treat same-sex relationships differently, they ought to receive equal treatment. And the reason that's given, if there's some reason that's being given for treating them differently, that reason has to be a neutral reason. So it can't be drawn from a comprehensive ethical or religious doctrine. And so those basic ethical principles, political principles within political liberalism seem to require recognizing same-sex marriage. So authors who've made this kind of argument draw both on neutrality from Rawls's earlier work and then political liberalism and his more developed later work. But both of these works share the view that policy in fundamental matters, right? And I'm assuming marriage and family law is a fundamental matter. It's part of the basic structure of society, as we heard earlier in Michael Pissarro's talk. Policy in fundamental matters should not be justified only by appeal to contested religious and ethical views. But of course, those are the kinds of views that are often given for the exclusion of same-sex relationships from legal recognition, right? So it's against my religion, someone might say, or it's against, what I think is the good life. And those are just ruled out by the neutrality principle as justifications for law and policy. Okay, so I said neutrality was kind of controversial. There are a few reasons why I start with neutrality, why I use it as a framework. So one is actually strategic and rhetorical because it's widely accepted. I think it's really interesting if we can show that the neutrality principle has much more radical results than the people who are employing it assume. There are other arguments for neutrality that I do find persuasive to some degree, right? So the idea that neutrality is required to treat all citizens as equal. So as citizens, we have different religious and ethical beliefs, and the state should try to stay neutral between them as a way of treating all of us as equals. So that's another reason I'm drawn to employing the neutrality principle. Okay, but then I think these arguments that I've canvassed for same-sex marriage just don't go far enough. So if you follow their reasoning, neutrality applies to a framework for adult caring relationships. And that implies that law shouldn't be justified by appeal to a religious or ethical ideal of what the good relationship or what the ideal or best relationship type is, but the kind of monogamous, romantic, sexual, exclusive, central marriage relationship, the dyadic marriage relationship that's recognized in current marriage law, that just is one type of ideal of the good relationship drawn from comprehensive religious and ethical doctrines. So we need to go further with the argument and see that not only should the argument not only does the argument entail that the law should not discriminate against same-sex relationships, it also shouldn't discriminate against relationships which are not romantic or sexual. So it shouldn't discriminate against friendships, right? And by friendships, I mean friendships which are not romantic or sexual. And it shouldn't discriminate against relationships which involve more than two people, whether those involve small groups like triads or quads that are polyfidelitous, or whether they involve networks or branching relationships where people might have overlapping relationships or relationships that aren't all part of a single unit. So if you think about it, I think it's pretty clear to most people that even same-sex marriage, when it's recognized in law, involves a failure of equal treatment, right? So it privileges romantic sexual relationships over non-sexual, non-romantic friendships. So many jurisdictions actually require sexual consummation, right? So this isn't a trivial, especially if someone has to go through like an immigration interview or some context in which they have to prove they're really married. This isn't a trivial requirement. It also clearly privileges monogamy over non-monogamies, right? So it doesn't allow groups of 3 or 4 people to get married or people who are in a network to get married to multiple other people. But if the exclusion of those relationships, of friendships and non-monogamies from recognition as marriage is premised on an ethical belief that such relationships are not of the same value as monogamous romantic sexual relationships, then the exclusion is unjust for the very same reason that the exclusion of gays and lesbians and same-sex couples for marriage is. So this is where the concept of Amato-normativity that Carrie mentioned before comes in, right? So Amato-normativity I define as 2 beliefs, right? So one is a descriptive belief. It's a belief that these romantic, sexual, dyadic relationships are normal for humans in the sense that they're what humans normally seek, that they're what we statistically normally are in, and another belief that they are normative, right? That caring relationships that are romantic and sexual and monogamous have greater moral value than mere friendships or than polyamorous or non-monogamous relationships, right? And you see this reflected. I mean, once you start thinking about Amato-normativity, you kind of see it all over the place, right? So you see this reflected in ways that people will treat just friends differently from someone's romantic partner, right? Just in terms of who gets invited to Thanksgiving dinner, right? So who is considered like the plus one? Who's considered as giving important reasons in someone's life decisions, right? So Amato-normativity is pretty widespread. So that differential treatment of romantic sexual couples and non-romantic friends in law and in social norms reflects these Amato-normative assumptions, which I argue are false, right? In the book. I'm not going to do that too much today. I just argue that they're false. So. In fact, so you could question, well, is the legal differential treatment of friendships and romantic sexual relationships, is that really premised on Amato-normative beliefs? Maybe there's some other really good reason for it. Maybe it's not just discrimination. But the fact that there's such widespread social discrimination against the romantically unpartnered, against those who are in friendships as opposed to romantic sexual relationships, and against the polyamorous, suggests it is Amato-normativity. It is this, I argue, discriminatory belief about the inferior value of these other types of relationships that underlies the legal differential treatments. So, of course, people can live in many different ways. Right, so when I talk about non-Amato-normative relationships, I have in mind friendships, I have in mind different kinds of non-monogamies. I also have in mind extended family members who might live together or share their lives in certain ways, small groups and networks who share lives and provide mutual care. Right, so all of these different kinds of configurations are excluded from the benefits of marriage. And I refer to these as care networks. And I'm really not, in thinking about them, the question of whether or not the people within them are in a romantic sexual relationship is not really important to me, right? What's important, and I'll explain why in a few minutes, but what's important is the fact that they're involved in these relationships or networks of care. And all of these different kinds of relationships are excluded from the benefits of marriage. But as we know, friends, people who are in care networks can exhibit long-term care and commitment. Right? So one example that always kind of tugs on my heartstrings are these two women. One, at the time when this picture was taken, they were living in Canada. They were like front page of the Globe and Mail, the Canadian newspaper, because one of the women was 83. She was Canadian. The younger woman was 73. They had cohabited for 30 years. The younger woman took care of the older woman who had heart disease and dementia. And the younger woman was American, and she had applied several times for the right to stay in Canada to continue, caretaking for her friend with whom she cohabited. And that application was turned down. Now, I mean, they could have got married, but they weren't lesbians. Presumably, they just didn't think of themselves as eligible for marriage. They didn't think of their relationship as marital. And because they didn't want to present themselves as lesbians and as engaged in a marriage type relationship, the relationship had no legal standing, despite the fact that it showed a much greater longevity and care and commitment than many romantic sexual relationships, which would qualify as marriages. And by the way, there was a happy ending to this story. So after it received national news media attention, the Canadian government decided to let the younger American woman stay. Okay, so the same reasoning that applies to friendships and non-sexual, non-romantic care networks applies to non-monogamies, including polyamory, whether polyfidelitous groups or whether branching networks. And it applies to polygamy. I mean, we heard a little earlier this morning about different neutral reasons that have been given against legally recognizing polygamy. But the central argument that polygamy, polyamory should not be excluded from marital benefits on the basis of ethical or religious reasons holds in this case, in the case of non-monogamies, as well as in the case of friendships or care networks. So if the reason that they're excluded from legal recognition is due to some ethical or religious belief about their value as a form of relationship, then their exclusion is just unjust. So there's an equal right to access the benefits and entitlements of marriage. Now, mononormative beliefs, so I'll use the term mononormativity to refer specifically to the assumption that the norm, the ideal relationships are monogamous. Mononormative beliefs may also reflect Eurocentric ideologies. They might be a relic of settler colonialism, as Kim Tallbear has argued, as Justin Clardy has argued. They might reflect racist stereotypes or racist ideologies. And so if they're reflecting those kinds of culturally specific or racist ideologies, those would also be non-neutral reasons, right? So that's further, that those reasons, those kinds of reasons could not justify excluding polyamory from equal marital status. And the fact that we can trace those historical lineages in the arguments that were given for the exclusion, the very racist rhetoric that was used in the argument that the Supreme Court heard, and actually Justin talked about this recently in the relationship rights series that Carrie mentioned, the very racist arguments that the Supreme Court rested the exclusion of polygamous relationships from marriage on give us reason to suspect, like, yeah, their exclusion was not based on good neutral reasons. It was based on non-neutral and very unjust reasons, ones that should not be tolerated. Okay, so I've been talking about reasons for excluding polyamory from equal marital status. Now, when I give this talk, I usually receive a bunch of potentially neutral conservative objections to recognizing polyamory, and it's great. I don't feel like I have to spend a lot of time on these in this crowd. So one reason, and actually Rafe Wedgwood mentions this at the end of his argument for legalizing same-sex marriage, which I think was from the 1990s in the Journal of Political Philosophy. And he says something like, well, of course, it might seem that this would apply to other kinds of relationships, but no one seriously wants those, right? So Stephen Macedo has also responded to me in this way, is that, this just isn't really, there aren't enough polyamorous, this isn't a serious social issue, we don't need to make legislation for this very small group of people. But I mean, I think this is just inherently conservative reasoning. I mean, how many, what is the percentage of the population that needs to be engaging in these practices in order for it to be a matter of justice that we take seriously, for one thing. But for another thing, of course, if you read Elizabeth Emmons on compulsory monogamy, there are so many forms of discrimination and so many penalties for polyamory that there hasn't been a lot of good research on the actual numbers of polyamorous until more recently, but because the very discrimination forced people into the closet. So I just think this is so these might be potentially neutral reasons. I just don't think they're good reasons for excluding polyamory from marriage equality. So the worry that polyamory is harmful to children, I mean, the arguments that claim that typically do a kind of sleight of hand where they're looking at research on very small, isolated, polygamous communities where there are other problems such as children are not being educated, boys are being expelled from the community in order to maintain gender balance. So the problem there isn't really polygamy per se. The problem seems to be these kind of wider problems in the community. Another argument that's sometimes given is that polyamory is inherently unstable, and for that reason, it's bad for children, or for that reason, we shouldn't try to legislate it because law needs to be stable. Yeah, so thinking about the effects on children argument, and this research has actually been brought up earlier in the conference. The first longitudinal study that was done by Elizabeth Scheff, which looked at children in polyamorous families over a period of 20 years and concluded, the children did not, in that very small sample set, did not appear to have any developmental difficulties as a result of being raised in polyamory. And the children reported the kinds of benefits and also inconveniences that you might expect in any sort of blended family, such as the Brady Bunch. So they liked that there were more adults to provide them with care. You know, the fact that there were more people in the household might sometimes seem inconvenient, but there's no demonstrated evidence that there's harm to children from polyamory. So the claim about instability, and I like bringing into the discussion some of these earlier advocates. They didn't use the term polyamory, but advocates of open relationships or free love. So Bertrand Russell, right, the famous philosopher, wrote a book on marriage and morals in which he argued for extramarital sex. And Russell's argument was that what causes instability in when there is infidelity is the expectation of monogamy. Right, so this is actually similar to the argument that was made yesterday by Ida Nami, the idea that it's the norm of exclusivity that's self-defeating and causing the problem in the relationships. And Russell says everybody knows that it's untrue that attraction to one person cannot exist with a serious affection for another. Everybody knows that this is untrue. And so in Russell's diagnosis of this norm of exclusivity or monogamy, what causes instability in monogamous relationships is the unrealistic expectation that people will not be attracted to people other than their partner. And I mean, in response to the instability argument, we can also ask, you know, how stable is monogamy, right? Looking at the divorce rate. Okay, so the central argument restated. So I tried to rule out some of the arguments that are typically given for excluding polyamory from marriage equality, which would be neutral. So the central argument restated: if friends and polyamorous exclusion from marriage is premised on the belief that such relationships lack the ethical value of romantic monogamy, their exclusion is unjust for the same reason that the exclusion of same-sex couples from marriage is unjust. Because those kinds of reasons should not be the basis for law. And so what that means is there's an equal treatment. There's a rights-based equal treatment claim or claim of justice to equal recognition for non-monogamous relationships. And this reasoning doesn't merely apply to access, right? So it doesn't merely apply to how many people can access marriage law at a time. I mean, one implication of the reasoning is more than two people ought to be able to get married at a time, or a person ought to be able to get married to more than two people at a time, right? Because we remove the mononormative assumption from marriage law. But it also applies to the content of marriage law itself, right? So if we think about the way that marriage law is structured, it reflects, at the very least, patriarchal assumptions. It reflects mononormative assumptions, and particularly in the kind of central piece of marriage law, that the people that get married reciprocally exchange this complete bundle of marital rights and entitlements. Right? So you kind of have to put all your eggs in one basket. It assumes there's like one other person you're exchanging all of these rights and entitlements with, and you do that in a completely reciprocal way. So it's reflecting monogamous ideals and the ideal as well that your monogamous partner will be someone who's at the center of your life, in the sense that they're kind of central to all of the other decisions that you're making, like decisions about housing and residency and employment and so forth. So if we want to remove mononormative and Amato-normative assumptions from marriage law, that doesn't just affect who can get married and how many people can get married. It affects what marriage law itself should look like. And so this is the kind of central argument in minimizing marriage. So as Carrie said, it's 10 years old, right? So this is familiar to many of you, I know. So for me, the really difficult question is, why not just abolish marriage? I mean, why should the state be involved in this at all? Why not just get the state out of the marriage business based on neutrality and equal reasoning? This is another way to treat everybody equally, right? If we want to treat everybody equally with regard to marriage law, just don't have marriage law for anyone, right? Just get rid of it, and then everyone's being treated equally. So why not leave it to the churches and to the Vegas chapels? Just leave it to various social organizations and institutions or civil society or religions. So there are different strands of arguments for this that are interesting. I mean, Jeremy Garrett is just a straightforward libertarian who thinks it can't be justified because you're spending taxpayer money on it. And Garrett's proposal for abolishing marriage is One that I find very problematic because he doesn't think of any replacement. And so if you just abolish marriage, I mean, you can imagine all of the functions that marriage serves in daily life. I mean, if we just abolish marriage, it seems like we need some sort of proposal for what to do about individual relationships, people's relationships in various contexts in society. So Garrett doesn't come up with that at all. Tamara Metz gives a political liberal argument for abolishing marriage. So her argument is marriage is essentially a comprehensive ethical status. So she compares it with something like a baptism or a bar mitzvah. So she wants to argue, the state can have, if it wants, it can have like ceremonies to recognize when people come of age or something like that. What the state can't do is have bar mitzvahs, right? Because those are inherently religious, they're inherently comprehensive. And she argues that marriage is the same, that it's inherently part of religious or ethical comprehensive doctrines. And she does come up with a replacement proposal, which is intimate caregiving unions that focus on people providing material care for dependents, like basically children or people who are dependent for care. Claire Chambers, she argues for the abolition of marriage on neutralist and perfectionist grounds. So I'm going to be talking about her arguments in a little bit. I think she really gives very challenging arguments, and we'll see why in a few minutes, for abolishing marriage. And Sunstein and Richard Thaler argued for abolishing marriage and replacing it with just civil unions, really as a way of defusing the whole political controversy over same-sex marriage. So their argument was more strategic. And they also didn't really think through, like, why do we have civil unions? Why do they take the form that they do? So it wasn't a very radical revisionary policy. So my view is we actually have a claim of justice that the state provide us with frameworks supporting and protecting our personal relationships. So kind of roughly speaking, we have a right that the state provide something like marriage law that protects and supports our personal relationships in a variety of institutional contexts. So the reason I give in the book, which I'm just going to kind of glide by here, but we could talk more about later if you're interested. So within Rawls's theory of justice, because he's committed to neutrality, he has to come up with a neutral account of the goods to be distributed in the just state. So he comes up with this idea of primary goods that he defines differently in different places. But one definition of primary goods is they're goods that are normally needed to pursue plans of life. Another, that they're goods normally needed to develop and exercise the moral powers. And so I argue in the book and in subsequent work, caring relationships are primary goods. They're goods, for one thing, they are so closely, there's extensive psychological literature showing that there's a close connection between caring relationships and self-respect and mental health. Right? And so they're closely connected to the good of self-respect, which Rawls states at one point is perhaps the most important primary good. Right? If we didn't have self-respect, we wouldn't pursue plans of life at all. So they're kind of non-substitutable foundations for the self-respect and the mental health goods that we need for the pursuit of our plans of life. So as primary goods, I mean, if the primary goods argument works, they're the basis for claims of justice or for rights claims. So I make this argument within a Rawlsian framework. Other people have been making similar arguments in other frameworks in what's now called the personal relationship goods literature. So that's a term that's used by Romanian philosopher Anca Gauch, personal relationship goods, where she looks at the way in which political philosophy in the past 10 years or so has been arguing, actually, the state should be taking seriously the goods in personal relationships and distributing this. So another philosopher who makes an argument in this vein, but in a very different framework in human rights theory, is Carrie's colleague, Kimberly Brownlee, who argues for what she calls social human rights, that we have, because interactions and relationships are such, they're constitutive of the good life as well as instrumentally good. And so we actually have human rights. The state provide us with the conditions to access and pursue personal relationships. So the basic idea is this claim that we have a right that the state provide the social and legal frameworks to protect our access and our pursuit of personal relationships can be made within a variety of political theories. So one objection is that the state can't distribute relationships themselves. Of course not without some kind of weird science fiction story about how it could do so, but it can distribute the legal frameworks and the social frameworks, which allow us to have proximity to our relationship partners. So things like special access for immigration eligibility, in-state residency in the U.S., which can support like reduced rates at colleges and universities and so forth. Flagging to employers that this person is eligible for spousal relocation policies, etc. Right? So the state can distribute these kinds of legal frameworks through institutions which protect our ability to have continued access to our relationship partners. Okay, so that's the case, that the state ought to support non-monogamies on an equal footing with monogamous relationships, and that it shouldn't do so by just abolishing marriage entirely, but we actually, as citizens, have rights that the state support and protect our relationships, polyamorous or monogamous. So what would that look like in law? And this is where I want to think about carefully this objection drawn from debates in queer theory over whether same-sex marriage is a good goal to pursue at all. I mean, why not just pursue non-discrimination and universal health care and just get rid of marriage? So echoing Paula Edelberg, since when has marriage been a path to liberation? Right? Why think that giving everyone access to marriage will make people better off rather than like just forcing them into this oppressive institution that feminists have shown is really problematic? So it's sometimes described as the worry about assimilationism, right? That if we have polyamorous marriage, it's going to subtly coerce polyamorous into dominant norms of relationships. So I wanted to think through that objection a little more. And I want to contrast two proposals, so Claire Chambers' proposal and my proposal, to kind of think through how those proposals might risk forcing assimilation. So minimal marriage is the proposal that I give in the book. And minimal marriage is just a radically revised law of marriage which places no principled restrictions on the sex or gender of the spouses or the nature or purpose of the relationships, except that they be caring relationships. So what it would allow is for spouses in minimal marriage to pick and choose from the bundle of marital entitlements and distribute them through their networks as needed. Or they could exchange them all with one person. If they want to do the monogamous thing, they can, right? They can just reciprocally exchange them all with one other person. Or they can distribute them through networks. And then there's a further point. So what would these marital entitlements be? They wouldn't be the ones we have now, right? They probably wouldn't be health insurance because in an ideal liberal society, everybody would have that. You wouldn't need to get it through marriage, for example. So the minimal marriage entitlements would just be that legal framework that supports and protects and recognizes caring relationships through protecting proximity and access and recognizing them in certain contexts where they might be threatened. Right? So there's a list of some of those rights, the rights which would recognize caring relationships to employers in a variety of contexts, and rights which would support proximity and continuing access in a variety of contexts. And so that's all that the minimal marriage entitlements would be. So an example of a care network, again drawn from the book, if this is seeming a little confusing to you. So we can imagine someone who lives platonically with a friend, right? So they share property and expenses. So they could use the tax benefit if one of them predeceases that comes with inheriting a marital domicile to protect their ability to stay in the house if the real estate values have risen during their relationship. She might also support and care for an elderly relative who could use certain benefits that are provided by her employer for a spouse. She might have a long-term love relationship with Stella, so if the state has any frameworks that protect love relationships or love and sex relationships, like conjugal visits in prison, if Stella should go to prison, then she could use those in her relationship with Stella. But she might have another friend who she would like to appoint as her end-of-life decision maker. So what minimal marriage would allow is for someone to distribute the minimal marriage entitlements in that way, or again, give them to all to one person. Or some of them could be given to more than one person at once, so they could be given within a group, so 3 people could all just marry each other reciprocally. So it would support all of these different forms of relationships. Okay, so Claire Chambers, as I said, argues for abolishing marriage, including minimal marriage. And the alternative that she suggests, so I said earlier as a criticism of Jeremy Garrett, like you need to have some proposal for how to replace marriage if you're going to get rid of this central institution. She calls them default piecemeal directives, and they're practice-based, they're not relationship-based. So the really important thing for Chambers, and the reason why she thinks this avoids stigma and hierarchy against unmarried relationships, is they're based on practices. So she doesn't have any ideal of a relationship, even a caring relationship, as the basis for these entitlements in law. So they don't specify any particular relationship status, even that it be a caring relationship. They just apply to people who are together in different functional contexts. And the 2 examples she gives are co-parenting or cohabiting. So if people are engaged in those things together, then there should be piecemeal directives which apply to them by default. So the law will have certain provisions, right? And she doesn't go into the details of what these should be, but it should have certain, whatever the just provisions are that should apply to cohabitors concerning, taxes and property division and so forth. Those should just apply by default, and then to preserve liberty, people can opt out if they want to. So they will not be forced to adhere to these provisions if they would prefer not to. So the piecemeal directives, and they're piecemeal because they don't apply to a central relationship. They just apply in these various piecemeal contexts like cohabiting or co-parenting. And so they wouldn't discriminate. They wouldn't engage in mono-normative or amato-normative discrimination because they're not specifying any type of relationship. So, I will voice a concern with this briefly, which it seems to me in order to justify and to specify legislation that would protect and support relationships in certain contexts, you have to specify a certain type of relationship that's being protected. And I worry that these kinds of piecemeal directives will not protect people who are in certain non-traditional relationships, right? So if people are living apart together, they won't be cohabiting, but yet they might want to recognize each other as decision makers or having special immigration eligibility in certain contexts. And there's no instrument within the piecemeal directives that would allow them to do that. Okay, so one of Chambers' motivations is to remove this specification of any relationship type and to remove the name marriage altogether, because she thinks that as long as there's a relationship type specified or there's legal marriage, it's going to reinforce stigma against people who are unmarried. So I want to think about whether, so I think there's the worry about whether it would underwrite stigma against polyamorous people who are unmarried. But I want to turn to the question of whether having polymarriage, right, particularly polyminimal marriage, would threaten forced assimilation into dominant mononormative norms. And so one way that I've kind of focused on this question was actually sparked by discussion with Francesca Miccoli and reading her really wonderful PhD thesis, which is this, we might worry that there's a tension between the definition of rigidity involved in law and perhaps the implicit hierarchy involved in legal recognition of relationships, and the fluidity and non-hierarchy involved in at least some understandings of polyamory. So this worry that there's a tension between love and the law is not a new one. I mean, you can see this through the history of philosophy. If you look at philosophers like Nietzsche and Hegel, who just had terrible reactions to the thought that we should base marriage on romantic love, right? Love and marriage have nothing to do with one another. But here we have Emma Goldman, who's a free lover, making the same point. So she's giving this kind of economic critique of marriage. It has nothing to do with love. It's just an economic insurance policy. But Goldman argues love is spontaneous, right? It can't be obligated. And so if you try to put it in this legal framework, you're actually going to undermine love because you're going to be obligating people to love or obligating them to stay in relationships with people where love can come and go. Love is spontaneous. Love has to be free, in Goldman's sense. Right? So I think there's kind of a similar worry lurking in the assimilationist worry about polymarriage. And so essentially I thought of three ways in which having minimal marriage or having polyamorous marriages recognized could be in tension with polyamorous values. And so the kind of structure of the three is the same. So the worry is there are these social norms around marriage, monogamous marriage, right? There are these social norms of centrality, that the relationship is central to your life, of hierarchy, that this relationship has greater priority over other relationships, and of fixity, so that the relationship will stay the same until it ends, and that the law will reinforce these social norms. So there's something about the law about legal recognition that will intrinsically reinforce centrality, hierarchy, and fixity, and so it will intrinsically be in tension with polyamorous values that reject those. And I think Claire Chambers' worry about marriage, and one of her central reasons for abolishing it, is the worry about hierarchy, or something similar to the worry about hierarchy. Okay, so the centrality idea, as I mentioned earlier, is this idea that the marital relationship is one around which all the rest of your life should be built, so it affects where you live, what you do, what decisions you make. And polyamory can involve central relationships, but it can also be open to something like diffuse nodes of relationship. And even more so, relationship anarchists. I mean, I kind of don't want to bring them into this because they don't want the state to be involved in any way at all, but even more so, relationship anarchy would resist this idea of a central relationship. And so the worry is, if minimal marriage is marking off some relationships, which are recognized through the minimal marriage entitlements, as more central to one's life plans than relationships that aren't, is it going to reinforce centrality? Okay, so another worry about hierarchy. Mono-normative marriage has this clear priority order. There's one relationship that has greater value and takes priority over other relationships. So again, polyamory can involve hierarchy, but it can also be open to fluid, non-hierarchical relationships. And so the worry, and I think this is very similar, although using slightly different language, to one that Claire Chambers raises in her book Against Marriage, is that minimal marriage would effectively reinforce hierarchy simply by marking off some relationships as having minimal marriage entitlements, which others lack. So Claire is really worried in particular about stigma and the kind of stigma that unmarried people and their children will encounter. So the worry is, as long as you have marriage, that's still going to underlie this distinction between two types of relationships, and one of which, the unmarried type, is going to be the target of stigma. So minimal marriage is still marking a distinction that could underlie these kind of hierarchical judgments about the value of different relationship types. And this is the kind of fluidity worry. There's this issue of fixedness, right? So social norms around marriage suggest that marital relationships are kind of fixed, right? So in certain ways, not in every way, but in certain ways, that the kind of ideal is that they'll stay the same until they end. So there's this idea like you kind of lock it down and then you've like fixed this relationship for the duration unless it ends. Whereas, and I think this is something Michael Bissaro brought up this morning, right? There can be in queer non-monogamy this idea of fluidity, right? So someone might be your lover, then they might be your friend, then they might be your lover again or your co-parent. So there can be greater fluidity in these kind of essential aspects of relationships. And so the worry is, even though minimal marriage can be exited, right? That's a crucial part of it. It's not fixed for life, but it still requires a caring relationship. So isn't it still fixing or assuming that the relationship has to stay fixed in this certain way? So then there's one more worry I want to raise here, which is the worry about subtle coercion. So with all of these aspects of even minimal marriage retain this kind of mononormative element, there's a further worry, which is having the kinds of benefits and entitlements associated within marriage will lead people to intermarriage or will incentivize them to stay in marriages in order to keep receiving the benefits and entitlements. And so that's going to render the choice to stay less than fully voluntary, right? So this is Claudia Card's worry about marriage, and she's one of the lesbian feminists who argues, like, we should just abolish marriage, like, we should not think of this as a good institution for everybody to enter into. And so the worry is, if people are being incentivized now to enter poly marriages so they can get these benefits, but if poly marriages involve centrality, hierarchy, and fixedness, because those are essential elements of legal recognition, then minimal marriage might actually change polyamory. It might change people's behavior in ways which seem somewhat problematic. Okay, so I want to argue that this isn't a problem. I mean, I think maybe there is a problem here, which is why I'm engaging with it. But I'll give 3 quick replies, and I'm really interested in hearing what people have to say. So for one thing, on the Claudia Card worry, remember that minimal marriage does away with entitlements such as health care or financial benefits, which might render staying less voluntary. So Claudia Card was worried about like people staying in marriages because that was the only way to get health insurance. But if the entitlements are this very restricted set of minimal marriage entitlements, that seems like less of a concern. The one exception might be immigration eligibility or in-state residence. So there might be some, which are still problematic. But secondly, remember, minimal marriage unbundles the entitlements and it supports networks. And so it implicitly recognizes the relationships need not be life-centering, right? So you can have various nodes of relationships, long-distance relationships, living apart together relationships. And it implicitly recognizes that they need not be hierarchical, right? Because there's a multiplicity of relationships in different contexts. It's not implying that any of those relationships are more valuable than others. And actually, I think this is crucial. Minimal marriage, the justification for minimal marriage would allow that people's most important relationships might be outside minimal marriage, right? So go back to the way that minimal marriage entitlements are used only within certain contexts where they're needed to maintain proximity and access in the relationship. So someone could have a friend in prison and they use the kind of access, what we now call conjugal access rights, that minimal marriage would give to people in prison to visit that friend. But that might not be their most important relationship. So because minimal marriage is disaggregating those entitlements, I think it's suggesting that those entitlements are only used in specific contexts. I think it pulls away from the idea that the ones that are recognized with minimal marriage entitlements must be the most important relationships in someone's life. And finally, I think by removing the specification of relationship type, it does allow for fluidity, right? It allows for the kind of fluidity we talked about before between being a romantic sexual relationship to a friendship, or even like a relationship where you really respect the other person and want them to make your end of life decisions, but you're not that close anymore. It would allow all of those different types of relationships. So I think it allows fluidity in the meaningful sense. And finally, so I know I'm running out of time, so I'll end briefly with this kind of further idea. minimal marriage would aim to change the social script around relationships because it removes mononormativity and amato-normativity from marriage law. And so I think part of the reason why we might see having minimal marriage rights, or why, like Claire Chambers or someone might see minimal marriage rights as reinforcing hierarchy, is because of the assumptions built into our social scripts about relationships, that there is a hierarchy. But the more that we rewrite the social scripts around marriage, the more we remove those assumptions that some relationships have greater value than others, and that they're central to life. So I wrote a paper on polyamorous weddings about how subversive weddings aim to change the social scripts around marriage. I think it's a difficult process. So there are these wonderful examples of polyamorous and other kinds of subversive weddings. So just as subversive weddings aim to change the social script around what marriage is, who you can get married to, what it means, I think by removing amato-normativity and mononormativity from marriage law, minimal marriage would start to change the social scripts around relationships by removing their legal imprimatur, by removing the law that underlies this. But we might still think minimal marriage wouldn't be sufficient to change the social scripts. We might need things like performance art to change the social scripts. So I think that's a very interesting question. Or as Francesca was suggesting earlier, we might need to change the terminology to change the social script. But so what does the ideal look like? So I'll finish here. So if we had minimal marriage, how might that rewrite the social script around relationships? So let's imagine for a second a post-monogamous, post-amato-normative society. Because relationships would be more fluid, because they would be more multiple, marital status would no longer determine someone's value. It wouldn't be on or off in the same way that it is now. It would no longer symbolize adulthood. It would no longer be a primary means of categorizing people, because the distinction between being in or out of a relationship would no longer be so important. And that might also give space not just for non-monogamies to flourish, but for romantic asexual relationships and friendships to flourish without being marginalized by cultural norms. Because if being in a certain kind of relationship became less culturally important, it might be more acceptable to just opt out of romantic or sexual relationships altogether. So that might be a rosy picture, but that's the thought. If a law of minimal marriage removes these kinds of assumptions socially from what a relationship should be, it could kind of counterbalance the assimilationist worries that being recognized as minimally married would trigger these kinds of assumptions about the meaning of that relationship, because it would permit more relationships to count as valuable. Okay, so I'll stop there. So thanks for your attention.